So welcome to the law. Now for some of you, this will be your first exposure to structured legal education. So I guess the first thing that I should say is that law is both an academic and intellectual discipline, but it's also a profession. That is, people do law. Barristers, solicitors, judges, consultants, government departments, people practice and do this from day to day. So while the subject is quite theoretical in nature, it's quite helpful throughout to use what we consider to be sort of real-world examples, ways to develop the skills of undergraduate students when they're going through and learning the various topics. Now, there's two primary sources of law. That's legislation and cases, case law, judge-made law. So it, and to be honest, legislation is the more common mechanism in which we derive things in law, but it's a little bit drier, and so you'll find throughout your legal education that a lot of case law is used because the examples can be very resonant. So the very first one that we're going to look at is about Wales. Now before we can talk about Wales in the Humane Society case, first much less exciting topic. I'm going to talk about referencing and citations, and ahead of time I want to apologise to those people coming from other disciplines who have learned a variety of simpler referencing and citation systems. The Australian Guide to Legal Citation version 3 is the Australian-wide standard across law schools for citing work. Now, I have to say this with a great deal of emphasis. Citation and citing and referencing matters. It's very important, and I think it goes beyond merely the plagiarism aspects and the acknowledgement of other people's works that you may have found in other disciplines that you may have studied, because in law we reference both primary and secondary sources in the work that we produce. So primary sources, cases, legislation, treaties and constitutions, and secondary sources are books, edited chapters, newspapers, URLs, journal articles. Now, I'm going to run through over the next few minutes just an explanation of this, which is quite possibly the first citation you would have been exposed to in your university career. So the name of this case is the Humane Society Incorporated and Kyoto Sinpaku Keisha Limited. It's from 2008 in the Federal Court of Australia. It was number 3. The judge was Justice Alsop. It was held, or the judgment was delivered, I should say, on the 15th of January 2008. And the particular reference that the author of the citation is drawing you to is paragraphs 2 through to paragraph 4. So I'm going to break that down a little further. The first part of the citation, and bold and red at the top now, is the name of the first party, the party bringing this particular action. Now, in a civil matter, at first instance, that person's usually known as the applicant. If the matter is on appeal, the appellant is the first name. That's the party bringing the appeal, which could have been either side of the case at first instance. If you see a capital R or the phrase the Queen or the King for older cases, much older cases, that represents the Crown, and in that situation that's a criminal matter. The flip side of that, the other side of the little v, is the respondent. Now this can also be referred to as the defendant sometimes. It's always the defendant or the accused in a criminal matter, and it's the respondent in an appeal. So it's defendant or the respondent. Speaking of the little v, In Australia, when the applicant and respondent, or the Crown and the defendant, are referred to, separated by this little v, it is pronounced and, where it's a civil matter. So this particular case here, Humane Society Incorporated and Kyoto Senpaku Keisha Limited. In criminal matters, it's pronounced against. So it's the Crown against Brown. Note that this differs from the American cases where they use the word versus. Don't use the word versus either in oral advocacy, in mooting, or in class. It's pronounced and. The next part is what's actually known as the formal citation. Now, this is to be honest, this is the most important part of the entire reference, because this contains the core information that you would need when using an electronic database to find that case. And there are heaps of them. Where it's got FCA, there are heaps and heaps of codes and styles for doing this. And I guess for those that are just starting out in legal education, I can express it in this way. If, for example, you were studying vet and you had to learn about parasites, you're only going to learn a couple of dozen parasites, and then you have to learn the rest as you go. You pick them up later. If you were studying geology, you're only going to get shown 10 or 20 different types of rocks. And when you go out into the world, you realise, oh, actually, it's a bit more complex than that. Now, law isn't actually that complex, because it's something that we made up. But there are, and I must sort of state this, there are many, many, many citation values and codes that can go there. Now, this one here, I just know off the top of my head, is the Federal Court of Australia. But the three components there, we just need to analyse for a second. It's got 2008, it uses square brackets. Sometimes you will see round brackets, sometimes you will see square brackets. And the important thing to note is that square brackets form part of the compound index. What that means is you must have 2008 in order to find this particular case. If it just said FCA 3, that would be case number 3 in the Federal Court of Australia, and we wouldn't be able to find it from the citation. However, other law reports series, for example, the Commonwealth law reports, which you'll get some exposure to quite soon, is where High Court cases are reported. And so, for example, you may have in round brackets 1998 volume 34 of the Commonwealth Law Report, starting at page 321. That will refer to a specific reporting series at a specific point in time. You actually don't need the year in order to find that. You can just find that particular series, find the particular page, and go from there. So where you see the year appearing in citations, in terms of searching, round brackets are optional. They're really just there to help the reader determine when this case was actually decided. Okay, the FCA part in this case stands for the Federal Court of Australia. What that means, though, is that this is known as a medium neutral citation. Back in the olden days, going back a few hundred years, we didn't have government agencies reporting on cases. In fact, they were all private people that would go and write and publish law series. And so the law series were often named after particular people, and you had to pay for them. That was the way that those particular practitioners would make a bit of coin. In more recent times, when there's an emphasis towards open data, and that idea that the law should be freely available for people to examine and see, there's much more of a trend for courts, particularly courts, appellate courts, the higher courts, to publish their judgments, and quickly. What that means, though, from our perspective, this is the reason why I say it's medium neutral. It's just literally the third case that the Federal Court of Australia heard in 2008, or third case they decided upon. That's how you would find it. The next part of the citation is additional reference information that you need to try and find that judgment, or really to embellish it to the extent that we can determine when and who decided it. This information, again, is not strictly necessary for finding the case. To find the case, we only need this part, the 2008 in square brackets FCA 3. We don't need the case name, we don't need the name of the judge, we don't need the date that it was held. It is, however, very helpful to do. Now, in the Australian Guide to Legal Citation, the AGLC, there is a specific rule for following for citing medium neutral cases like this. It's in Rule 2.8.1 on page 52. Usually, by the way, if the staff are recording, they will give you the rule number, not usually the page number, because they can vary according to printing. So in this case, you'll also see that it says Allsop J. The J just simply stands for judge or justice. It's always capital J. Occasionally you will have other acronyms after there. It may be LJ for Lord Justice or CJ for the Chief Justice, sometimes P for President. It really is the title of the judge. Another thing to note also, if you see JJ, that refers to multiple judges. It's actually just the plural of judges. Not necessarily that they're in a joint judgment, but that they sat together on the same case. You'll see multiple judges appearing in appellate cases in the High Courts. The final part of the citation is what's known as the pinpoint reference. Now, this particular citation in the square brackets refers to paragraph numbers. It's very, very common in medium neutral reporting citations, because they don't, strictly speaking, have pages, because you're just referring to case number 3 the federal court had. When the transcript comes out, it's usually just numbered in terms of paragraphs. So it's very, very common for medium neutral citations to use paragraphs. However, law reporting series, such as the Commonwealth Law Reports, will use page numbers. And basically the only real rule there is you can use both if both are available, but you shouldn't mix and match. So, for example, if you are citing a case in the High Court in the Commonwealth Law Reports, it's not appropriate to use paragraph numbers in that particular case, and you actually may find the paragraph numbers reset with each judgment. So that's just something to watch for. And note here with the paragraphs, we don't put the letter P in front of that as you do in an APA and other referencing systems. You have just a dash between them, and they're both in square brackets. If we were referring to pages, we would put either a P in front of it for a single page, or two P, so just PP, and not have them in square brackets to refer to pages. So the next part is to look at the body of the text. Now, this is a series of bullet points on a PowerPoint slide. If you're producing academic work, don't use bullet points. One of the core graduate attributes for law students, and particularly those intending to be legal practitioners, is the ability to write. Sometimes it convey quite complex ideas in complete sentences. Bullet points are not an appropriate mechanism for using that. But these are slides. Now, this is another primary source that's been cited, what we call in text or in line. Now, the first part, which I've highlighted here, is the name and year of this particular piece of legislation. It's important to note that this is always in italics, including the year, always in italics, single space between each of them, and followed immediately afterwards with the jurisdiction. 3-letter code, with the exception of Western Australia and South Australia, which are just SA and WA, and in brackets, and these are not italicised. Now, it seems a little bit odd and a little bit frustrating and very finicky that you've got to do things in a certain way, but it's really about maintaining a consistent style, and it is something that I guess a consistent thing that you'll see in legal education and legal practice, going and doing things properly and representing that a particular piece of work is of high quality. It's often reflected in the attention to detail, and that's something to remember when you're for those that do continue on to legal practice, that small things matter, small details matter, punctuation, spelling, and referencing and citation. So it's I think it's important to really sort of emphasise that now, for it to sort of pervade your legal training throughout your undergraduate degree. So the jurisdiction in this case for this piece of legislation is the Commonwealth. It's a federal statute. And immediately after it, we've got what's known as a shortcut. And this part's actually optional, but I wholeheartedly recommended your academic writing doing this to create a shortcut. What it means is that next time you refer to the Environment Protection and Biodiversity Conservation Act 1999 Commonwealth, you can just put the acronym in italics, EPCBA. For those familiar with academic word count and word limits, it's a very, very useful mechanism to reduce your word count, which would mean that this particular citation, EPBCA, takes up essentially one word, as opposed to 1, 2, 3, 4, 5, 6, 7, 8 if you were citing it in full. Now, you'll note further on, this is cited further down towards the bottom, and so in the next sentence where we've referred to it. So the shortcut, the shortcut citation is in round brackets. It has a single quote on either side for not in italics, but the text itself is in italics. And every subsequent time it's referred to, those references are in italics as well. Now, the pinpoint references, in this case, point to particular sections of that legislation. Now, there's a bit of a style thing here. You can write this as an application under section 275. I find it's a little bit wordier. So in my academic work, I generally would write this is an application under the Environmental Protection and Biodiversity Conservation Act 1999 Commonwealth, and then put S space 475 to represent the section. It's just it's one or two words shorter. You'll also note that with that second citation, it's got SS. Much as I mentioned before, when you've got multiple pages or multiple judges, it's the way, conventionally, by the way, things were pluralized in Latin. There's a lot of Latin that comes into law. But in this case, it means sections. The plural of section is SS when you're citing it. Seems a little bit odd, but I have to say that it is certainly not subsection. That's something different again. And we'll see further down, I haven't actually quoted it, but highlighted in red, but the last sentence says pursuant to section 475 subsection 7 of the EPBCA. So just make note there, SS means multiple sections, it's the plural of section, and subsections are actually directly after the section you're quoting and in brackets. Okay, so the next citation in this on this slide is actually an international document. Now, these don't traditionally come up very much when one's writing academic pieces of work and research, and certainly in your legal research for those that intend on being practitioners in specific areas. It's quite rare that you cite international treaties and materials, but in this particular case, it's found in Rule 7 of the AGLC. And it's structured in that particular way. The name of the convention or treaty in italics, then a comma, when it's open for signature in that exact format, open for signature 2nd of December 1946, comma, then the name of the treaty series, and then leaving a space, then the date that entered into force, again written in that exact same style. The dates, by the way, in legal academic writing are always formatted with a single letter, the full month, and then the full year. That's how dates are cited in legal work. I suggest with non-breaking spaces too, for those that know Microsoft Word. Just after that, you'll see a shortcut. Again, this is the same style that was used above with the EPBCA, although I have just noted that there's no subsequent citing of that on this PowerPoint slide. Generally, you only shortcut if you're going to use it again. There's no real need to create a shortcut if it's not going to be reused in the same document. Note the pinpoint reference for this particular convention is article number 3. Again, where it's got ART, there are very specific rules in terms of how you write out that it's an article or a section or a a component or a paragraph, ART for article, and in this case the original document was in Roman numerals, and so we have in the citation we use Roman numerals here as well. Sometimes it could be just the Arabic, in other words just the number 2, like it is for the paragraphs at the top, but in this case the original was in Roman numerals. Right, so let's have a look at this case. Now, for those continuing on with legal education, this website, Ostly, really is the major source of all Australian legislation and case law. There is, again, as I've alluded to earlier, there's this push towards open data, this idea that us as citizens have a right to be able to go and see what the law is without the need for structured legal education. Now, at the top of this case that you'll see on the screen, you'll see the what they call the breadcrumbs at the top. It's got UA here, Ostly databases, the Federal Court, 2008, and then the particular case that we're in, the third case from 2008. This is actually a very, very interesting case, and I wholeheartely recommend that all of you do go and have a read. The language can be a little bit daunting, but it's very, very good practice at the start. It's very, very interesting because basically the Humane Society, which is an organisation incorporated under, I believe, the New South Wales Incorporated Association legislation, a not-for-profit group, was trying to seek an injunction against it's actually an arm of the Japanese government. It's run as a separate company, but basically they run ships that slaughter whales and are obliged to sell the byproducts of that, which is under the guise of scientific research, to the Japanese public. The reason why this is such a fascinating case is that it deals with the notion of futility. Now, they talk about in this case that the injunction that the organisation is seeking is really an order by the Australian court preventing the Japanese company from the slaughter of whales inside the jurisdiction. Now, the really interesting and certainly in my mind very tricky part is in paragraph 13. It's very important within the subject matter of this particular course because it really talks about sovereignty. The Australian Antarctic territory is actually only recognised by 4 other countries, 4 other sovereign nations, and so this dispute that they have is really an issue of sovereignty. Now, they talk in paragraph 13, they're talking about this as grounds for invalidity, something that the Kyoto Senpaku Keisha would have argued throughout the proceedings that look, hey, this land, the high seas are not part of Australia, therefore the Australian courts can't do anything. They have no power to create an injunction or other sorts of orders outside their own territory. For example, the Australian court can't order, say, a Russian citizen residing in Mongolia to pay money to Australia. It just makes no sense. Now, a very interesting sentence there that's mentioned there when they were referring to the invalidity of the Act is this matter of sovereignty. Now, a very important point just must be noted. It first came up in Coe, the case of Coe that we'll do later in this course, and again in Mabu number 2, that courts themselves can't question or challenge their own power. It's kind of circular, really. If you had the power to rule yourself invalid, then you wouldn't have had the power to do that to start with. And so the judge here has quite rightly said these issues in terms of whether things are disputed or not disputed, these matters of matters to do with international relations, they're really outside of the scope of the courts to be able to adjudicate one way or another. Now, one of the core problems with this case, and certainly the respondent in this case argued quite strongly, was really to do with futility, because the particular organisation isn't in Japan. It doesn't have any assets. It is in Japan. It's not in Australia. It has no assets in Australia. It's never likely to ever have any assets in Australia. So creating an injunction or seeking damages from such an organisation is, and certainly was argued this, is really an exercise in futility. And it's important to note that this the High Court has in the past certainly said, look, where you can't achieve any outcome, there's really no point in going to the court. So this particular argument was actually rejected by the court here. Look, even though they can't actually achieve any particular result inside Australia, it really is a matter of almost a symbolic matter or gesture, that creating or setting this injunction gives or signals that this particular behaviour in our particular economic area is still not something that we condone. And so the court there rejected, in paragraph 53, this idea, this practical difficulty, the real practical problems with serving and really with being able to maintain this injunction as a mechanism for not granting the order. So, and you'll see in paragraph 55, in fact it's quite common, by the way, when you're doing research, legal research involving cases, often to skip to the end. Sounds like a bit of a terrible shortcut, but it's often helpful to find what the judges actually said, what orders they made. And certainly something to remember in legal practice, this is the only thing you care about when you go and make an application to the court, or one is being sought against you. You need to find out what the court actually is going to do. And so here they created a restraining order. They said, yes, this particular respondent is to be restrained from killing, injuring, taking or interfering with Antarctic minke whales in contravention of the Environmental Protection and Biodiversity Conservation Act. Whether or not this has any impact or effect, that's really a matter outside what the court's capable of doing in this particular case. And arguably, this is a matter of it's really a symbolic gesture, and the actual enforcement or non-enforcement of this particular injunction is really going to fall down to diplomacy and international relations. It's a very unusual case to start with your legal training, but very, very interesting to read, and I wholeheartedly recommend that each and every one of you sit down and just carefully read through this. If nothing else, it's a good start for legal research. So we're talking about legal institutions in this subject, and a very helpful way to start is to really break down what that means. So when we look at the word institution, really there's three ways you can go about looking at that. The first is, I guess, as an establishment or an organisation with a specific, usually with a specific purpose or role. So for example, an example of organisations such as this are Parliament, say the Federal Parliament, or the National Australia Bank, James Cook University, or the Cowboys Rugby League Football Club. The second way of looking at it, which is related, is to do with the physical place that an organisation is in. So in that case, the the Houses of Parliament in Canberra, or a large building with a red star in it at 500 Burke Street in Melbourne, the Smithfield and or Douglas campuses at JCU, or what used to be called Willows Sporting Complex. I believe it's 1300 Smile Stadium in Thiriet, Galloway for the Cowboys. Now the third one, and really the one that we're most concerned about in this particular course, is looking at an institution really as a tradition, a cultural, sociological phenomena. So a definition could be a custom, practice, relationship, tradition, or behavioural pattern of importance in the life of a community or society. Now, from a sociological perspective, it's the institutions from this aspect are considered to be mechanisms that govern people's behaviour. They impose some form of order and structure, and they're ongoing. They continue above and beyond the people, sometimes all of the people that are in them. So in terms of examples, the Parliament, as part of, I guess, a part of our democratic tradition, is an institution. The National Australia Bank, as an institution, it's something that forms part of who we are and our identity, and it's usually long-standing and means something. And certainly with the example of the James Cook University as an institution would continue even if the organisation changed its name or was dissolved, and the place changed its name or was dissolved. It's that idea that it forms part of people, part of our identity, and again, referring back to the Cowboys, they could change names, they could change stadium, but you will still have people that will support their team till their final days. So in the example of legal institutions that we are going to look at, the courts, and in particular the Queensland courts, the Magistrates Court, the Court of Appeal, the High Court, are all examples of legal institutions. The various Houses of Parliament, legal institutions. The relationship between states and with each other, states inside Australia and nation states in the general sense, and how they relate to each other in terms of international law. These are all legal institutions that we will look at in more depth throughout this course. Now we come to what's possibly the most difficult slide that you will ever see throughout your legal education. What actually is law? And I can say unequivocally, I don't have the answer to that, largely because it's a question of philosophy. It's something that you will have to engage with as you go through both your legal education and your times in practice, and reflect upon it, because your view about what the law actually is may change over time. In fact, it almost certainly will. So when trying to examine different ideas that people have about what the law is, some theorists look at the law as being a system of commands derived from the sovereign. Others look at the idea that the law is something that we recognise as being official. Others look at the habits that people have in terms of following laws, and again recognising that the other actors have authority to enforce things against us. And other theorists look at the idea of governance. Law is something that that just maintains the relationship between us as citizens and provides some form of social order. Still other theorists look at law as being something that flows from culture. It's something that a tradition that we've always had. So it's a very, very nebulous question, and one that I really take it I suggest that at this stage in your education that you have a good think about, because as you learn more about the law, and you will do as you continue through this course and beyond, you're really going to have the chance to think about what it means, not just to you, but also what it means to other people. And so the questions there on the slide are there to help you think about what the law is. Is law to do with politics? Arguably, we elect politicians, and they, through the mechanism of Parliament, create laws which are then applied and adjudicated by the courts and really carried out and executed by the executive arm of government. You may also note that it's no coincidence that Parliament has a lot of lawyers in it. Without being too cynical about it, I have to mention that as you continue throughout your legal education and into practice, you will notice and note the power dimensions of law. You will become more powerful as you start to appreciate what the rights and responsibility and the powers that are given to various people, not just in the political arena, but in other spheres too, in business and, to be honest, in and around the university. People aren't given unfettered discretion to do what they want and do terrible things to you. And so when asking the question, what is the law, there is certainly a political dimension or aspect to it. The second question there is law morality. Well, arguably some part of the law does flow from morality. Morality is, in the very broad sense, concerned with what's right and what's wrong, what's good and what's not good. In legal society and change, the LA1103, you will learn about it, these philosophical frameworks: natural law, legal positivism, and legal realism. Natural law is the idea that the law itself is derived from morality and must always be inherently responsive to it. A famous line in Latin from Saint Augustine, which was picked up by a later Catholic scholar, Saint Thomas Aquinas, is "Lex injusta non est lex." An unjust law is not a law. And so that idea of natural law really comes from the idea that there are some good things that people have or they seek to go and be, and law should at least be responsive in some way to that. And certainly this is enshrined in some things. The US Constitution uses a famous line in it when talking about the rights and freedoms of people. It says at the end, "We hold these truths as self-evident." And really that's an expression of natural law. We're not deriving this from anywhere. We think that our law should inherently respond to what is some form of inherent good in human beings. The next concept there is legal positivism, which is really sort of the opposite of natural law. It's not saying that law shouldn't come from morality. Well, of course it does. We elect politicians, they create laws. What the legal positivist says that, look, once things are enshrined in law, it is the source of morality. What we think is right or wrong should be reflected in the law, and then once it is enshrined in that legal institution or those processes, that is the source that you refer to, not the underlying morality itself. It's a very, very important distinction here. Sometimes you will have laws that everybody thinks may be inherently unjust, but it's still the law. When, for example, from time to time, I'm sure everybody listening to this has jaywalked at some stage. What we did was, strictly speaking, against the law, and we're liable to a fine of some sort, but very few people would consider it to be immoral. And so in that aspect, the law and the breaking of law may not be consistent with the idea of morality. Now, the third aspect of philosophy I just want to mention, this idea of legal realism, it's not really so much related to the other two, and it's completely pragmatic. It's sort of saying, look, the law is what lawyers and judges and politicians do. This is a practical discipline, and really all of this fluffy philosophical stuff, it's not really relevant when trying to determine what the law is. You can see what the law is. It's what people are doing when they go to court. It's those letters in the mail with your speeding or speed camera fine. That is the law. It's what people do as a phenomena, what people do as a discipline, and it's reflected in the mechanical nature of law itself. So whether or not it's responsive to morality or not isn't really relevant. Law is what people do. That is legal realism. Now this final question, is law justice? That's significantly harder to answer than the previous two questions. And if any of you listening to this now are completely turned off by all of the subject matter and you want to go and do something, I guess, more scientific or practical with your life, I pray that you please just heed this message here. People throw the word justice around willy-nilly, and it's a very difficult word to define, largely because what I consider just and what you consider just are two quite different things. Justice in the broad sense is to do with the right action, doing things correctly, achieving some notion of fairness. But when trying to determine what's fair, it opens up many cans of worms, and it can change in terms of context, change in terms of environment, and it certainly can change in terms of who is being affronted the justice. I will certainly throughout this course refer back to this, but I'll just leave you with something to ponder. It actually came from an experienced practitioner here in Townsville who, when dealing with some quite awful series of personal injury laws, and he said to me when I was taking notes on behalf of a client one time, he said to one of a client who wasn't going to achieve some form of he wasn't going to achieve any form of compensation for his injury, and he said, look, at the end of the day, I hate to say this, but we don't, what's happened to you is really unjust, but we don't have a system of justice in the state of Queensland. We have a system of law. And so I'll leave that question with you now to take away. So really what we want to do here and what we want to achieve is an understanding not just of the underlying legislation and case law and treaties that you'll examine and all of the subsequent substantive law subjects you'll do, but it's really looking at the superstructure. What is the system that the law operates in? What are the institutions inside the law? And in particular, how do they relate to each other and to you, the citizen? Trying to think about what the law is, which is hard because there is no very clear, concise definition with universal acceptance, is still a very useful thing to do. And I think in terms of trying to create this working definition, it should be noted that it's definitely a system to do with rules. Law is about rules, and I think the other really important word is power. And so if we think about rules and power as two very core concepts that really should form the lens in which you go about looking and reading legal, academic and primary sources throughout your undergraduate course and again in practice as well. Law as a mechanism can regulate and it control and it can coerce, make people do what they don't want to. The mechanisms of that legislation, case law, constitutional documents, area of law known as equity that we'll get to as well, and the mechanisms of international law we'll all talk about in more depth over the next 13 weeks. Throughout this time, it can be helpful to refer back to this material and ask yourself these questions. How does the law, or our understanding of the law, help maintain the underlying social order? How does it go about regulating society? 2, is it true to say that law reflects the values of society? Is it inherently responsive to those values? Or were those values set in stone? Can they be changed? If a law that is perceived to be unjust by most people isn't changed, is there a problem with our system? And what are the mechanisms that we can go about, us as citizens, or groups, collectives of citizens, to go about changing the law? We're going to learn these things. And also we're going to look at critique. What are the underlying dimensions and problems that are going to that happen when we go about trying to make changes? Are all changes a good thing? So the next thing I want to talk about is ethics. Now on the screen you'll see an extremely broad definition of ethics. Now, much like justice, ethics is a difficult term to come to grips with, and it, again, from this point, it may be helpful to really start with a broad set of definitions for that. So the slides are taken from one of the dictionaries, the Macquarie Dictionary, to do with rules and conduct, systems of moral principles, and they talk about what's right and wrong. Now, ethics is a very robust discipline in its own right, and really there's 2 major branches that I'll just discuss now. The first is to do with what we call normative ethics. That's really, in the broadest sense, the philosophical inquiry to do with what a person ought to do, what is morally correct in actions. And there are sort of 3 broad schools within this field of normative ethics. The first is to do with what they call virtue ethics, and that is the active or the moral worth of an action is really to do not so much from the result of the particular action, but it's really to do with the qualities of the person doing it. We look to people, be it real or imagined, to have certain qualities of a good human being, and we look at the mark of our own actions in relation to what that perfect person would have done in that situation. What am I doing or acting as this moral person would do in the same situation? The second category of normative ethics is known, they're sometimes called the teleological. They look at not so much at the underlying quality of the act, but usually to something external, and largely this is the underlying consequences of a particular action, so that an action is morally good if the consequences of that action lead to a good outcome. What's a good outcome? Well, there are many schools of thought as to analyze different competing and sometimes contradicting theories of what a good outcome is. And you may have heard of the discipline of utilitarianism. That's a school of thought, a consequentialist school of ethical thought, where they hold in the broader sense that the best moral action is one that leads to the greatest good for the greatest number. Sounds like the I guess the bastion of economic theory, that a good thing to do is something that's going to make the most people happy, and in contrast with that, the fewest number of people unhappy as a result. The third of these normative theories are known as the deontological theories, and really they're to do with not so much looking at the consequence, not so much looking at what a perfect person might do in the same situation, but really looking at rules and duties that people have, and the following of those rules and duties is what leads to, I guess, is the best ethical course of action to do. And so a famous example of this is a German philosopher called Immanuel Kant, who posited what we call the golden rule: do unto others as you would have them do to you. that's an example of a rule-based, a deontological system of ethics. So as well as these normative theories, which are theoretical in outlook, there's another very large, very important area of ethics known as applied ethics. And certainly throughout this course, and for those that continue through their legal education, the discipline of legal ethics itself is something that we'll study in quite a lot of depth. You're also, well, strictly speaking, the fourth year legal ethics subject is an elective. It is actually mandatory to become a practitioner. So you can get a law degree without undertaking formal studies and a full semester of legal ethics. You can't become a solicitor. And I must also note that the graduate diploma, so the post-studies qualification you're required to undertake to become a practitioner, well, you'll actually study legal ethics again in a great deal of depth. It's very, very important. And I hope even at this stage in the career that that you do take very seriously the obligations and principles of ethics and legal ethics on board. So the final thing I want to talk about today is to do with critical thinking, and in particular thinking critically about the law and the legal system. Now, critical thinking is really about looking not just at the subject matter that's placed in front of you, but going deeper, understanding how and why particular legal systems and structures and processes came to be, and thinking about ways that they could be improved. It's far more broader than a rote learning exercise. Now, this is a very, very helpful thing to do and to get involved in very early in your studies. And it's also very useful for those that seek to go into legal practice to be continuously reflecting and analysing and being critical about the processes and institutions and in day-to-day legal practice and life. Now, historically, the place of the academic discipline was to provide critique, and the role of practitioners was, well, to practice. But certainly in more recent times, this is far more, the two are far more interrelated. You'll find throughout your academic career that most of your lecturers and teaching staff have, at some stage, or are in the process of becoming legal practitioners themselves. And so it's very useful to both engage with the material at this stage and just try to think or find holes, find problems, find things that don't make sense, find things that could be done better. This way of looking at the material that's placed in front of you will make you a much better student and a much better practitioner. The quote there, by the way, from Professor Nick James is very apt. Critique painting a picture of the law not as a body of dead rules, but it's a political mechanism, a social phenomenon, and really this is the key word, it's imperfect. The law is not perfect. You will see many times, both throughout your studies and in practice, where systems that have been put in place just don't work. Now, part of studying and being a student is that you are actually required to analyse not just the black letter law, the case and legislation that you'll receive, but to really think about it, engage with it, and to try and, in your work, to express ways that things could be done better. When examining critique, students from time to time express very simply to us, really, what's in it for me? Well, there's really two sides of this coin. The first one is that, look, it's going to make you a much better student and a much better practitioner. Going and analysing the underlying problems with any particular subject, it's going to mean that when you're reaching that point, it means you've already mastered the basics. The other, I think, far more pertinent thing is that performing critique on rules and laws, systems, processes and institutions that are in place, it's fun. It's far more interesting to have a very thoughtful, analytical argument about something that isn't working than a very surface level of regurgitation of the underlying material that we've learned, some of which can be very, very dry. So one thing I'll leave you with is the application of critical thinking to the Humane Society case that we discussed earlier. Now, some questions that you could ask and think about to do with that are things like, what's the point of an Australian court making a decision like this, creating an injunctionship that lies outside its jurisdiction? Is it going to make a difference? Do the whales care? Is the boarding of Japanese trawlers by citizens acting on their own or by Australian government vessels, are they terrorist acts? Would it be reasonable for the Australian Federal Police to stop and uphold the injunction by boarding these vessels? Now, it's really, I have no answer to these questions myself, but I think it's very helpful here to just start looking at the cases and the reasoning behind both what the judge is doing and the actors that are playing a part of these cases, to start thinking about these and analysing them. And I think it's very, very helpful as an undergraduate student this early on to really start thinking about the connections between things. Why do the various actors do what they're doing, and what does the result mean to each of them? And I believe that this will be of great benefit to you all, both as undergraduate students and, I hope, as legal practitioners.